Check.
Testing.
Texting.
Stranger. Attending meetings.
We're close, maybe.
Right. Exchanging greetings. Strangers in
We're
the-
on. You have.
No stranger than me.
All right. We'll wait till Inspector Parker tells us we're good to go.
Yep.
I thought Inspector Gadget.
It's.
Okay.
We're good. All right.
Right.
Yay.
Okay, we're back now after some technical difficulties. You want to provide a quick
We'll give you this brief synopsis.
synopsis?
Okay. So this is a project called Standardizing Lincoln's Integrated E-Construction, and it is a $100,000 pilot project to try to use GPS to measure, draw, and pay for project elements such as fire hydrants, water valves, pavements, and things like that. It's an 80-20 split from the Federal Highways Administration, and I envision this to be an asset tag in asset management. It's fire hydrant, whatever that is. That then will move through as the element's designed. It's in the drawings, and then we know where it is in construction. And when we measure it with GPS, it's automatically measured, paid for, and drawn at that time. And then it goes back to assets, so that asset knows that they have an asset. So some of the things we hope to do are do more with less people, be more accurate. Results in one step for record drawings. Right now we have 3 or 4 hand-drawn things that go through the system. If it's faster with less people, that we think might be less money, or better things with the same amount of money, whichever way you want to look at that. And it's safer for our guys in the field because we don't have them down in the trench measuring things. So that's the synopsis version. How's that?
Thank you.
Great.
Are there any questions from the council?
No.
Okay, seeing none, thank you so much.
Thank you.
Is there anyone else here that would like to speak on this item? Okay, seeing none, we'll go ahead and move on.
We can now vote on this item. Item 1A is approving a LPA program agreement between the City of Lincoln and the State of Nebraska Department of Transportation for the proposed automated infrastructure delivery program introduced by Shob.
So moved.
Second.
Moved and seconded by Councilman McGinnis. Any discussion? Seeing none, may we please call the roll?
Raybold?
Yes.
Ward?
Yes.
Shob?
Yes.
McGinnis?
Yes.
Washington?
Yes.
Beckius?
Yes.
Bowers?
Yes.
Motion carried 7-0. Okay, that ends our consent agenda. We can move on to Section 3, Public Hearing Liquor Resolution. I'll be calling item 3A, application of Down the Hatch, Inc., doing business as Down the Hatch to expand its Class I liquor license by an area measuring 9 feet by 9 feet for a walk-in cooler at 5601 Northwest 1st Street.
Is the applicant for Down the Hatch here? Hey. Want to come up and say your name and address and tell us a little bit about your application?
Lindsay Kroger, address 5601 Northwest 1st Street. We just added a walk-in cooler, an additional walk-in cooler, because we ran out of space. Pretty simple.
Any questions from the council?
No.
Okay, seeing none, thanks so much. Is there anyone else here that would like to speak on this item? Seeing none?
Mr. Shob.
Thank you, Mr. Chair.
Thank you, gentlemen, and I apologize. Mr. Chair, seeing no one else coming forward, I'd like to move approval of this item.
Second.
Moved and seconded by Councilwoman Washington. Any discussion? Seeing none, may we please call the roll?
Washington?
Yes.
Ward?
Yes.
McGinnis?
Yes.
Raybold?
Yes.
Beckius?
Yes.
Shob?
Yes.
Bowers?
Yes.
Motion carried 7-0. Okay, that concludes our Section 3 of the agenda. We'll move on to Section 4, Public Hearing Resolutions. I'll be calling item 4A, Use Permit 15002B, application of Tomsek Novak Investments to amend the existing use permit by adding 9.89 acres and adding 203 dwellings to the total allowed by the use permit, with associated waivers on the property generally located at Northwest 12th Street and West Highland Boulevard.
Good afternoon. Brad Marshall with Olson at 601 P Street, Suite 201. I'm here on behalf of Tomsek Novak Investments. This essentially is the third phase of Project Up, basically Highlands Boulevard and Northwest 12th Street. Back in 2015, I believe it was actually city property that was turned over and declared surplus, and the first phase of this project started. The the apartments, I should say, have gone very well. Additional land has been brought in phase 1, phase 2, and now phase 3. This portion is actually part of the business park up there. It's a 03 zone property. And we're in front of you today basically asking for apartments to be as a use that would be approved in the 03 designated area. About 10 acres and 203 potential units and dwelling units as part of this overall project. Might have broke it again. There we go. First phase was just basically way up on the north end of the properties here. Phase 2, which was mostly along Northwest 12th, and now you can kind of see on the southern end, about 10 acres here that we're adding additional units. A couple of waivers that are being applied for with this. Basically from a 20 to 30 foot setback along Northwest 12th. We are dedicating additional right-of-way for a future right turn lane when that is warranted. And along the north property line, we are asking for a reduction of rear yard setback from 40 feet to 15 feet. And then last one is a height waiver, basically. Anything over 35 feet, the additional setback is typically required off of those property lines. We're asking that to be waived. The first phase project, which is basically going to be the same units applied in phase 3, are just a touch over about 38 feet, if you will, in height. The reason that we're asking for those waivers, and we believe that it's a good fit, there is an I zoning, industrial zoning to the south. And so working with the planning department, we've been asked to try to position those buildings as far away from that industrial zone property to the south. So as you can tell, a lot of these buildings and so forth are pushed up against that north property line. Highlands Golf Course is to the north, a lot of open space, a couple of tee boxes kind of down in this corner. And as part of that, here are the second site plan. The one that I was showing was another rendition, but we took these buildings in the west corner and we put those a little bit further to the north as well. We repositioned some of the detention and actually provides a little bit better buffer to the industrial zone property to the south. With that, I'd be happy to take on any questions that you may have.
Are there any questions? Councilman McGinnis?
Now, the second plan that you showed,
Yep.
is that the one that will be official, or is the first one the official?
Well, the conditions of approval basically ask us to reposition the building. There was a building that was more positioned to that southern edge of the property. We have moved those to that northwest corner. So we are accepting the condition of approval to relocate those buildings as far as to the north as possible. We've run that by Rachel, and she's happy to say that those buildings are about as good as we're going to get them on that property.
Okay. And two, so Rachel and planning are okay with having housing next to I-zone at this point, right?
The recommendation is that we take on and position those buildings as far as we can. We were not giving, in some cases we've talked about a set distance. I know Health and Human Services reviewed this, and the direction that we were given was to do the best that we possibly can to get those away from that I-zoning to the south.
Okay, and then along your west property line, there's railroad tracks, and where the housing's a good enough distance away. What's the distance of railroad tracks and housing? Isn't it over 300?
Typically, I think that might be usually the recommendation, but in this case, Health and Human Services does not make any comments on that.
Okay, so they're okay with having it within 300 feet also. And then the other question I have, there's a high-pressure gas line that goes down West Highlands Boulevard.
There is, yep. But basically, it starts on the south side of Highlands Boulevard, if you can see my pen here, that's about the position of where that high pressure, it starts basically on the opposite catty corner of that intersection.
And it
So when you
follow-
look on those GIS maps and turn on the high pressure PPA zones, those actually are off the property. They don't. We did work with Rachel to position that building on Northwest 12th Street as far north again, provide some green space and parking there, and shift that a little bit further north.
Okay.
Any further questions?
And then,
Sorry.
yeah, one other quick question. I was looking at the access and stuff. This being an I zone, there will be large trucks that will use West Highlands Boulevard a lot.
Very likely.
Yeah, and even park over there as they do now. And I'm wondering if that would be a concern.
It's a public street. I know two things. One, I guess, as far as parking is concerned, I've seen the parked vehicles there myself. If the city were to impose any type of restrictions, I don't think it won't cause, I mean, the apartment complex provides all the on-site parking.
Okay,
as
so
it
if they
is,
had to put up no parking signs along
Yeah. The
Highland
owner's actually
Boulevard,
been
Northwest 14th.
very cognizant of how much parking is on these apartment complexes. He is an owner builder, and so we've looked at those ratios. We've actually tried to mimic a lot of what was done in first phase, where things have gone very well from the parking ratios. And then I think at Planning Commission, I think there was some discussions about the speeds along Northwest 12th, but I think all the city can do is take and advise those speed studies in those particular areas for those zones.
Okay, thank you.
Councilwoman Washington?
Thank you, Mr. Chair. Mr. Marshall, I have a couple of questions. First, the Parks Department, I mean, I understand moving them far away from industrial, but you're moving them a little bit closer to the golf course, and so I'm curious, how did the Parks Department respond to having development closer to the line, reducing that setback?
So during the first phase of the project, we worked really closely with the Parks Department. We actually encroached some of their grading into the golf course driving range, and worked very well with them. We're actually doing the same thing here because we have positioned that the land is sloping generally east to west as it falls towards the airport, and these big long buildings they're flat, and so it does take quite a bit of grading to flatten everything out. And so we have been in contact with the Parks Department. We are working with them, I suppose, to come to a resolution on some of these things. And that does include doing some grading and then adding additional landscaping as far as some of those buffers. There's actually a really nice tree line to the north. The Parks Department to the west through here, it's just kind of like a prairie grass that's baled every so often. But there, like I said, there are some tees down here which we are a little bit closer to grade and trying to minimize impacts. So
Okay. Yeah, I would also be somewhat curious about the fly zone of balls going into the apartment complex, but I know which direction they're supposed to go.
Right, yeah. Actually, this is nice because everything's hitting west and north, and first phase is a little bit more complicated where they were actually hitting right towards, and it's usually a topic of conversation I bring up with the owner, is to just ask, how many balls, they get a long hitter once in a while, but
Yeah.
the trees and everything that they have planted have helped.
And then I have one other question, and this might be a question for yourself or for Director of Planning, David Carey. I understand the rules we have about keeping residential away from industrial, thinking about health and safety of the residents, but having residential development come in before industrial has been cited gives me some concerns for the future industrial area. What will they have to do in order to be sited next to a residential area? Are they going to be constrained in their ability to develop that parcel under current zoning?
Well, I can tell you from our application and discussion with the planning department, I think I asked that once as to the positions that we've been asked to accommodate as much as possible. My understanding was we were not imposing restriction onto those properties, where we've actually seen that 300-foot line or something position off the buildings, and that can then exceed the property that we have available to us, and then impose a restriction. That might be a really good question for David, because I was not led to believe that we were imposing a restriction on the industrial zone property already.
David Carey, Director of the Planning Department, 555 South 10th Street. So what Brad just said is correct, that we would not be imposing additional restrictions on the existing zoned industrial. And then I'd like to also add that this property that we're talking about today is already zoned O3, which already allows residential. And so that was a dynamic that we're dealing with here to make the best situation possible, given the proximity of the industrial zoning to the south. So we have not been in a position to not allow the residential because of that proximity. So we're trying to, with the setback adjustments, trying to move those buildings, the residential buildings, as far away as possible. And then with this approval, would have that condition kind of set there, but it would not be imposing a restriction on the industrial to the south.
Any further questions from the council? Okay, seeing none, thank you both so much.
Thank you.
Thank you.
Is there anyone else here that would like to speak on this item? Okay, seeing none, we'll go to move on.
I'll be calling item 4B, accepting and approving the report of new and pending claims against the city for February 1st through February 15th, 2022.
Is there anyone here that would like to speak on this item?
I think I'm up. I am Nicole EC at 2240 Breckenridge Drive. On January 19th, I was taking some books back to the Isley Branch Library and hit an unmarked pole in the library parking lot that was intended to hold a handicap sign, but the sign was missing. And I am here seeking to have my deductible and insurance covered through the city. And last I knew, you guys were checking to see if there was a statute on the time frame for when the city had to fix that. So,
Are there any questions from the council at this time? Okay, what I'll do is I'll have you take a seat, and then I'll see if anyone else wants to speak on your claim, or if council has any questions for any staff.
Yep.
And if they do that, I'll give you an opportunity to provide rebuttal.
sounds good.
Is there anyone else here that would like to speak on this item or this specific claim? Okay. Does the council have any questions for staff? Councilwoman Washington?
Yes, in Ms. EC's question, oh, you don't need to rise again, but because she asked the question, and I know that we asked it of our city council, if our city councilor would come forward, that would be great.
Yancy Christie, City Attorney, 555 South 10th. I am unaware of any requirement that the library put a cone on top of the pole, and I don't know that I don't believe that there is a requirement, like a time frame for that, or a time frame for it's not spelled out a time frame for the pole, any sort of signifier to be put up. What I can tell you is that the law, I believe, would look at this as a question of notice. Again, this was the recommendation from the law department was for denial on the basis of a lack of notice. Once we, the library, received notice that the sign was missing, the contractor indicated the sign would be replaced. Contractor failed to act. We don't have any reason to believe that the library knew that the contractor failed to act. After receiving notice of the claim, the city, through the library, contacted the contractor again, who promptly cured this problem and put up the pole. again, one of the things that we, maybe not again, but one of the things we also will consider with this type of scenario when we're in the negligence arena would be whether something was open and obvious. Certainly, I think there was a question as to whether this would be considered open and obvious. Certainly our position in the law department when we looked at it was that if there is something that is a danger that is known or obvious to the invitee, someone who comes onto that land, then there is a lot of, then the case law would suggest that if the risk is apparent, open and obvious, that the owner of the property is not liable. So that was something else that the law department considered as well.
Any other questions for City Attorney? Councilwoman Raybold?
You know, it seems like the contractor should be held responsible for this. And so if the city council denies it, what would Ms. Zisi's next steps be to try to get compensated for this? Would she request or file a claim with the contractor's insurance company? Or I know you can't dispense legal advice, but what are the next steps if we deny it? I mean, it doesn't sound like if she filed a claim, a different claim in small court, that it would proceed forward, where, unless she filed it against the contractor.
Well, I would say that without trying to do best to answer your question, I think generally speaking, when the claims are at this level denied by the council, there's always the option to go to court. So that option exists to every claimant. And some of these issues that I talked about today could be presented to a court of law. I think that whenever there is a third party, someone else involved other than the city, there's generally speaking other options available as well. If someone wanted to try to go another route that does not involve a claim with the city, a claim against the city.
Okay. But would you be able to discuss those other options with Ms. Easy?
I have no idea. I have no problem talking with her about process that is available to her.
Okay. Thank you.
Are there any other questions from the council? I have a question. You want to go get Tom? The question that I have is, so Miss S.A., E.C.? E.C.? Okay, thank you. Miss E.C. didn't do anything illegal, but it's the claim that the contractors did not tell the city. So someone informed the contractors, but the contractors didn't tell the city?
So we do have, I think, Ms. Glass here from the library as well, but it's my understanding that the city told the contractor, and yes, the contractor did not. It was our understanding, I think, that it was fixed by the contractor. She's coming up here, maybe I have it wrong, but that's my understanding.
Tracy Glass, Assistant Director, 136 South 14th Street. So when they knocked it down, they informed us that they had knocked it down and that they would replace it. Yes.
So the contractor told you all that they had knocked it down and they told you that they would replace it?
Correct.
And that happened, was that November, if I remember correctly?
That was missing, yes, November 15th.
And then so from November until this claim.
Correct.
Is when we were notified that it was not.
So if we approved her, Ms. E.C.'s claim, could we hold the contractors accountable then? Because I mean, it sounds like, if Ms. E.C. didn't do anything incorrect, the city was told, but the contractors didn't do what they were supposed to do with the city. I guess I'm thinking that would fall on our responsibility.
So.
You know what I mean?
I'm always hesitant to speak in absolutes, and just to be clear, I hear you saying, well, can't we just get reimbursement for the contractor? That's really what I think you're asking me, and I don't want to just stand up here and say that is absolutely how it will play out.
Okay.
What I can say is the city has general indemnification in every contract, right? You can't do contract like this with you can't get a contract like this with the city to do work and not have insurance, indemnification, contract clauses in there. Those are, and what you're talking about is indemnification. And those are standard contracts or standard language that is in every contract, but those are oftentimes interpreted by courts if the parties don't agree.
And so since the city had told the contractors that the sign had fallen, we had done everything that we needed to do, even though we, the city, essentially continued to see over the next couple of months that the sign had not been replaced.
I don't know that there is evidence of what the city saw in between.
Right.
I understand that you suggested that the city saw that it wasn't there, that it hadn't been fixed during that time frame. We didn't, at least at the law department, we were not presented with any evidence that people, that the city or any city representative was aware that it wasn't fixed and didn't do anything. That was not the fact scenario that was presented to us.
Okay. Have there been any other accidents since the sign went down? I know the sign's back up now, and the sign went back up after Mrs. EC's accident. But were there any other accidents between November and January?
No.
No. Okay. All right. Councilwoman Raybould?
Can you tell me, did the library make the contractor aware that someone had an accident and that they needed to get it fixed ASAP?
From what I understand, yes.
Okay. And then how long did it take for the contractor to come out?
It was up by the next day, so it could have happened that evening, but it was up by the next day.
And tell me again the time period between when the contractor told you the sign got knocked down and they would come back and take care of it, and then when did the incident happen again?
So it was down November 15th, and then the accident was the 19th, and so it was back up the 20th. When staff noticed it was up the 20th.
Okay. Thank you.
Any other last minute questions? Okay. Thank you so much. And then I'll invite Ms. EC back up to provide a rebuttal if she wishes to do so.
I guess I just had a couple more questions for the city attorney. If I can address him, is now the proper time to do that, or I guess the council in general.
I would say that if you have questions, you could email them in, and if there's something that the council can answer through that way, that'd probably be the most appropriate way to do that. For the public hearings, it's usually not a back and forth between city staff and residents and whatnot. So I think if there's more information that you would like to have about process or whatever, I would send us an email.
Okay, so then, I mean, I realize that there's an option to take this to court, so I guess I speak to you about doing that. I guess I'm just confused to what I need to do, because I do feel that the city is liable here.
So,
yeah.
Yeah, so what would happen, or I see our city attorney standing up.
Well, I was just going to reiterate, I think I was already asked to speak to her after this. And so I would have no problem speaking to her after this.
So there's not going to be a resolution today?
No, there will be a resolution today. When we get to the voting session, after we've gone through this item, our clerk will vote on the item that was right before here. I think it's like 4A.
Yeah.
And then when we get to 4B, then the council could have a conversation about moving your claim to the approved list.
Okay. And then I do want to clarify that the sign was put up the same day after I had the initial incident. I called the library, and then I went back to take more pictures when I had a vehicle to get back to do that. And the sign was then posted it happened at 10 a.m. and it was posted by 4 p.m.
Any questions for Ms. EC?
And I have pictures of that.
I don't have a question, but I have a comment. And I'm sure our council can talk to you about all the different options, but what I see is, the contractor failed to perform I don't know if you filed it with your insurance company, but then the insurance company would go after their insurance company and subrogate it, because rather than try to go through the cities.
They told me this was my first step, so,
Okay.
yep.
All right, thank you.
Okay, thank you.
Thank you so much. I believe we had another claimant that was here that we had put on delay.
Yeah, Ben Powell, 614 North 26th Street, and my claim was in regards to the curb stop. So this is just a walkthrough of the typical process of turning off a curb stop. And I think the claim was just going to be reviewed today, so I'll turn it over to the city attorney and then have a rebuttal.
Is there any information you'd like to remind the council about, or any information that you want to bring up? Because you'll have a chance to provide rebuttal also.
Sure. Do I need to restate what was said last time, or? I know a couple of you weren't here, so okay.
Yeah, go for it.
Yeah, so our basement contractor had called Lincoln Water System to turn off the curb stop in order that, you know, if anything happened to the pipe while basement work was being done, that there would not be a leak. Our house was built in 1907. It's a great classic old house. The curb stop was difficult to turn, and typically curb stops in general need to be turned very carefully, especially old stuck ones. But unfortunately, that's not what happened, and more force was applied, and the valve was broken, which just means that it now cannot be turned off. There's no leak, but now it cannot be turned off at the curb. The curb stop, according to city code, is the homeowner's responsibility. However, in order for curb stop work to take place, usually there is a waiver signed, and homeowners should be notified of their responsibility prior to the work being started. That was from a water system employee. And it's also here on the, other side, sorry. This is the water manual. So 922, premise owners should be aware that significant damage can occur to equipment or premises when water is turned off and turned on, of which we were not aware. And 924, customers shall be required to sign a water turn-on form and agree to pay applicable service fees, which we were not provided. So just seeking reparations for that, and I did not bring the exact number today, but it was, I think, around $4,700. Thanks.
Right, we might have some questions for you. Councilwoman Raybould?
And then, did you already get it fixed, or that's just an estimate that you have been provided?
That's just an estimate, yeah, from John Henry's, yeah.
I do have a question for staff, because I know, just so you know, the question was whose responsibility is to maintain the curb stop, and I think we got some additional information from the director of LTU.
I'll tell you what, let's see if anyone has any more questions for Mr. Powell. If no one has any more questions for Mr. Powell, then he can have a seat, and then we'll bring city staff up. Are there any more questions for Mr. Powell? Councilwoman
I just
Washington?
have one, Mr. Powell.
Yeah.
Because I know that you said that your contractor called the city to ask this, or to notify the city work's going to happen, right? And
Right.
and so they were working on. So you've hired the contractor notifies the city. The contractor and the city are talking to each other on site when there's a need for some assistance and
Yep.
opening about. Okay, and so are they? I just wanted to make sure I understood that, so that they were acting really on your behalf. At some point, the contractor is acting on your behalf.
Right, the request to come and turn it off, he would be acting on our behalf. Yep.
All right.
But the signing of the form to, release responsibility or liability, it wasn't given to the contractor or to us, so.
All right, thank you.
Any other questions for Mr. Powell? Okay, seeing none, if you want to have a seat, then we'll bring up some city staff, ask some questions, and you'll have a chance to provide a rebuttal.
Sure, thanks.
Thank you. Councilwoman Raybold, is there a specific staff member you wanted to talk to?
If Liz Elliott is here, or she was here earlier. Or the question is,
Johansi Christie. I just know that Director Elliott is not here.
Oh,
She
okay.
was here earlier.
the question is, I believe Director Elliott did send us information because we had questions. Whose responsibility is it to maintain the curb stop when you have an older property?
I think in this case, I believe the curb stop is located in the property owner's yard, I think, is that? If I could just have 1 second. Okay. So looking at the information that I have from the director of LTU, I think that this was, the valve curb stop is located in the property owner's yard, correct? And that's, so your question was who was?
It came down to, I believe Director Elliott said it is the responsibility of the landowner to, the property owner to maintain the curb stop.
Mm-hmm.
And I'm trying to find the email where she explained that to us, and I didn't know if that is the case.
Yes, I think that is while I understand that Director Elliott is not here, it's my understanding that the email was provided to the council explaining that. I would note, I think we talked a little bit about this last time, and I understand it's an unfortunate situation. It's always an unfortunate situation when I have to stand up here and talk about these things. But the paperwork to sign is if LTU is going to charge the $25 fee, then they want the property owner or the representative to sign that form and acknowledge that they will pay the $25 fee. In this case, the form was not signed, nor was the $25 fee imposed on the property owner. I do think that last time I was here, I may have implied that excessive force was used. I just want to be clear that the city employee who was present has reported that it is his position that excessive force was not used. I understand that. Again, I wasn't there. I understand that Mr. Powell wasn't there, and I understand has already presented a different scenario, and I understand that. But the city employee who did turn it off indicated that excessive force was not used, nor was he told by the representative to use less force or anything like that. So,
I have a question. So when the contractor invited the representative from LTU to come and assist with the water situation, what if, I know this is a what if scenario, what if the representative from LTU accidentally backed up and fell into a priceless lawn ornament and damage the lawn ornament, wouldn't the city say, okay, we'll pay for the lawn ornament that was damaged in the course of doing the work on behalf of the city? I'm just trying to think, when do we hold our workforce accountable for incidents like this?
I find it hard to believe that there would be a scenario where we have someone on the property and they fall and, I think as you explained, and damage something within the house. Like
No, a priceless lawn ornament.
Priceless lawn ornament.
You know, something that had been in their family for generations.
You know, without, all of these things are really fact specific, but I mean, I don't know that, I find it hard to believe that under the scenario presented to you, that would be in front of council. And what I mean by that is claims that are, you know, paid are usually just worked out and just come as a vote of approval.
I understand. And I guess the determination by LTU was that the valve was old. It was time to replace it, and in their best efforts to try to turn it off, it broke.
I think that's right.
Okay, thank you.
Councilwoman Ward?
Thank you, Mr. Chair. Mr. Christie, the thing that's troubling for me, and it may be that I don't understand the use of the form, the two things, besides the cost of the estimate for the homeowner, $4,700, the fact that the form was never signed by either the contractor at the home, and my understanding is the homeowner was not home at the time, if I recall correctly. And so without that form signed by the contractor who was representing the homeowner, does that make the city liable despite the $25 that wasn't paid, despite all of that? The legal question I have for you is, without that form signed and the work was done regardless, and now we have this pending expense of something that hasn't been repaired, without that form, does that change anything for either side?
Certainly, I would say no, it doesn't. I understand the concern that you are raising, but again, I think that the form, while I don't know that I need to read the form in its entirety, although I'm happy to do it if someone requests me to do that. I think it talks about it will not be turned off without the owner or the owner's representative being present. And then it talks about, it cites the code, which indicates that it's the owner's responsibility to keep the equipment in good repair and operable at their expense. And it also talks about in this form that Lincoln Water System will not assume any liability for damage, breakage, or repair. The form also says that the Lincoln Water System will also charge a fee of $25 to the property for customer requested water, for the customer that requested water turn-ons and turn-offs for the service call. Service fee will also be charged in the event that they cannot perform the service. So, I mean, it says other things as well.
So in other words, LTU, the city cannot, is the form kind of irrelevant sometimes? I mean, we're going to go and, if there's someone there representing the homeowner, we're going to go and do the repairs regardless of the form. I mean, when you're facing a $4,700 bill, $25 doesn't, because we waive that, I don't see that as that helpful, to be quite honest.
Mm-hmm.
I understand what you're saying.
And the form is not, you know, it's not a legal requirement. It's not in the code or anything like that. It's
that's fine. Okay.
LES's internal form that they have created, their policy.
All right. Thank you.
Any further questions for our city attorney? Okay, seeing none. Thanks so much. Mr. Powell, would you like to provide a rebuttal?
So as a teacher, whenever a teacher has a rule, the rule comes from a story of a student who did something, right? Or the coffee cup that says caution hot, so somewhere along the way, someone spilled it on themselves and claimed that it was, the restaurant's fault, McDonald's or whatever. So I don't know the story behind this form, but probably somewhere along the lines this happened before, and a form was, designated as the thing that would help it not happen again. Unfortunately, in this case, it did happen again, and I guess I sort of rest my argument again, both in 922 here, that says premise owners should be aware that significant damage can occur to equipment or premises when water is turned on or turned off. That's not something the average homeowner knows, and so I think it's Lincoln Water System's responsibility to make us aware of those plumbing things. And then finally, 924, that customers shall be required to sign a water turn-off form. So, that's really all I have. Thank you for considering this.
Any last minute question, Councilwoman Raybold?
Yes, I have one last question, Mr. Howell. So the estimate that they gave you to repair, who would be performing that, and would you need the assistance of the city to shut off any water if you have to replace that valve that broke?
Yeah, so the standard procedure would be to shut off the main at the street because, the curb stop valve is obviously not operable. So, the city would have to turn off the main, that supplies our street or whatever while the repair was being made. I contacted, I think, 4 or 5 different plumbers to give an estimate, and 4 of them said the job is too big for them because it requires excavation, and so only like the really large companies like John Henry's have the equipment necessary to make this type of repair. So that's why the cost is a little bit more, because of the extra equipment needed to excavate and the extra experience. So there's only 1 or 2 companies able to do this kind of work.
Okay, thank you.
Yep.
Any further questions for Mr. Powell? Okay, seeing none, thanks so much. Anyone else want to here to provide comment on this item? Okay, seeing none, we'll go ahead and move on.
We're now done with that section. We can vote on the items. Item 4A is use permit 15002B, application of Thomasek Novak Investments to amend the existing use permit by adding 9.89 acres and adding 203 dwellings to the total allowed by the use permit with associated waivers on the property generally located at Northwest 12th Street and West Highland Boulevard, introduced by Shob.
So moved.
Second.
Moved and seconded by Councilman McGinnis. I thought I was hearing things for a minute. Any discussion? Seeing none, let's call the roll.
Ward?
Yes.
Beckius?
He has to abstain.
Oh, excuse me. Raybold?
Yes.
Washington? Yes. McGinnis?
Yes.
Shob?
Yes.
Bowers?
Yes.
Motion carried 6-0. Item 4B is accepting and approving the report of new and pending claims against the city on February 1st through February 15th, 2022, introduced by Shob.
So moved.
Second.
Moved and seconded by Councilwoman Washington. Any discussion? Councilwoman Raybold?
I'd like to make a motion that we approve the claim for from Mr. Powell, but only in the amount of $2,350. The actual claim requested was $4,763. It's hard for me to try to compartmentalize that I do think that perhaps some of the responsibility lies with the city and some also lies with the homeowner. So that's why I made the suggestion that we split.
Okay, so there's a motion from Councilwoman Raybold to approve Mr. Powell's claim in the amount of $2,350. Is there a second?
Second.
Seconded by Councilwoman Ward. Any discussion? Councilwoman Raybold, do you want to kick us off?
Well, I think I already
Okay.
said it.
Any further discussion? Councilwoman Washington?
I have a hard time voting to approve this. And some of it is based on personal experience. I know that the water stops, curb stops are the responsibility of the homeowner. I don't know that I need to know why the city was called for assistance in turning it on or off. But the curb stop itself, we pay for the fee of having them help us turn it on or off, but the curb stop, the maintenance of it is in fact the homeowners. And I recognize that on a house that's 1907, 1906, I mean, it's an old home, the curb stop is old, perhaps. And sometimes curb stops are made of lead. Sometimes they're made of, or they are connecting to galvanized. I mean, I've been watching my neighbors have curb stop issues up and down the block, coming closer and closer to me. And I must admit, after this last session, I went and checked my curb stop because I decided I don't want to be surprised. I want to plan on that charge. But I can understand it's very expensive, but it's a responsibility of the homeowner.
Any other discussion? Okay, seeing none, let's do a roll call on Councilwoman Raybold's motion to approve Mr. Powell's claim in the amount of $2,350.
Beckius?
Abstain?
McGinnis?
No.
Raybold?
Yes.
Schob?
No.
Ward?
Yes.
Washington?
No.
Bowers?
Yes.
Tie.
Tie, 3-3.
So if there's a 3-3, it's not approved then. Okay, we're back to the main motion. Any discussion on the main motion or any other amendments? Councilman McGinnis?
I don't know. I'd like to, I'll make a motion that we move Nicole Acey's claim to being approved from denied.
Moved by Councilman McGinnis. Is there a second? I would ask for a friendly second, at least for discussion.
Mr. Chair, I will assist with that second.
Seconded by Councilman Schob. Councilman McGinnis, you want to start off?
The only comment is that the contractor knew that they had done something wrong, and I don't believe it's her job to go around and do this. I think it's something the city should be going back to the contractor directly instead of having her go through court or through all of her insurance to try to get this money back to her. So I think it's something that the city ought to pay and then go after the contractor for at this point. It's the way I read it.
Councilwoman Raybold?
And I don't read it that way. I read it as it's the contractor's responsibility, not the city's, and that her remedy is to work through her insurance company, and then they are in turn to approach the contractor to find relief or a settlement from the contractor, not so much the city's responsibility.
Any other comments? Councilwoman Washington?
My concern is that because of our contractual relationship with the contractor, we may not be able to collect.
Okay.
Any other? Sorry.
I have one quick question for Esquire Christie. Would that mean, could we be part of a lawsuit or part of the insurance claim? Would they go ahead and keep us on that?
I ask your question one more time, I'm sorry.
If her insurance company sues our insurance company or whoever, would we be part of the claim? Or if they sue the contractor's insurance company? We would be a party to that suit, right?
I think it is possible that we could be a party. Yeah, I think that is possible now.
Okay.
Yeah, I think so, but
Okay, so we'll be in this one way or another, maybe.
Any other comments? Councilwoman Ward?
Doesn't mean that I believe that we should be there or that we will remain there,
Yeah.
but just, is it possible that we could be a part of it? Yes, it's possible.
Okay.
Councilwoman Ward?
Thank you, Mr. Chair. Would have trouble supporting your motion, Councilman McGinnis. It's not that I don't have sympathy with our claimant. I found myself in similar situations more than once with my things I've been high-centered on in various parking lots across our city, and so I do sympathize. But I just am trusting my instincts here, and I do think it's the contractor's responsibility and not the city's. So I just want to clarify my vote. Thank you, Mr. Chair.
Any other comments? I'll make a comment. I'll be supporting Councilman McGinnis's motion to amend. Ms. EC didn't do anything illegal. It sounds like the city knew that the sign was missing. We had told the contractor. I believe that the city has a responsibility to work with responsible contractors who will act in a timely manner. And I don't believe that November to January is a timely matter, especially with it being on city property where folks had seen it every day since January. And the sign went up the same day after the accident had happened. If I had any hesitation, it would be that there was no other accidents. However, like I said, I believe the city has a responsibility to work with responsible contractors. And if we are not working with responsible contractors, I do feel like that we need to take responsibility for that, either through holding the contractor accountable or working in the future with contractors that will respond quickly to a safety hazard.
I have a point of clarification.
Yeah.
I thought the incident happened in November. Did I get that? Write down the date wrong?
The incident happened in January, but the contractor became aware that the sign was missing in November.
Okay, thank you. I thought it was.
Pardon me, I must have understood wrong. I thought that the sign came down on the 15th of November. And they notified us on the 15th of November, and the accident occurred in the parking lot on the 18th or 19th of November.
I think the accident happened in January 20th.
Can I come up? Is that okay?
Actually, I would love to have you do that. However, if we don't follow the rules for this portion of it, but I'm advocating for you here. I'm on your team.
So make sure the dates are right.
So, City Attorney Christie.
I would invite Ms. Glass up,
Okay.
if that's okay.
Should I introduce myself again?
Yeah.
Okay. It was November 15th was the date of when the sign came down. It was January 20th.
That the accident occurred.
January 19th, I'm sorry. Sign went up.
Thank you.
Yes.
Any further questions or comments? Okay. So again, just to kind of reiterate, the fact that there was such a long period of time in between the sign falling and then the accident, I'm not saying that's on library staff at all. I'm saying that that's on the contractor for not being responsible and getting that done in a timely manner, and that the city should have responsibility for that. Seeing no other comments or discussion, let's go ahead and call the roll on Councilman McGinnis's amendment to move Ms. EC's claim to approved.
Beckius,
Abstain.
McGinnis,
Yes.
Raybold,
No.
Schob,
No.
Ward,
No.
Washington,
No.
Bowers.
Yes.
Motion lost, 2-4.
All right. Now we'll have to go back to the main motion. Any further discussion on the main motion? Okay, seeing none, let's go ahead and call the roll on the main motion.
Beckius,
Abstain.
McGinnis,
Yes.
Raybold?
Yes.
Schob?
Yes.
Ward?
Yes.
Washington?
Yes.
Bowers?
Yes.
Motion carried 6-0.
All right, we'll go ahead and move on.
That concludes our Section 4 public hearing resolutions. We'll move on to Section 5, our public hearing ordinances, second reading, and related resolutions. I'll be calling items 5A and 5B together. Change of Zone 20036, application of Chance Hanshaw to change from AG Agriculture District to H3 Highway Commercial District on property generally located at 8230 South 91st Street, and the related conditional annexation and zoning agreement between the city and Chance Hanshaw property generally located at 802030 South 91st Street.
Good afternoon. My name is Ann Post. I'm an attorney with Rembolt Lucky Law Firm. I'm here today on behalf of the applicant, Chance Hanshaw, regarding this change of zone. So the first thing I want to do is to orient you to give you an idea of what we're asking for. So we're asked, this is a change of zone for a 3-acre parcel at about 91st and Highway 2. And we're asking to change it from AG zoning to H3 commercial zoning. And so why I want to emphasize that is because this isn't the same as the special use permit that was before you earlier today, where we were talking about 10 acres, 200 units. What we're talking about here is one single parcel of real estate. This is an individual that owns it that wants to build one building on it. And so I want to reorient this conversation as we continue to discuss this change of zone. So why H3 in this location? Let's see, here's a map of the property. You'll see that it's a 3-acre parcel. It's currently zoned AG. AG, ag, 3-acre parcel, isn't very economical to use for agricultural purposes. You can't grow much on 3 acres. You can't do much with agriculture on 3 acres. And so also you'll notice, if we change to this is a map with the current zoning of the property, you'll notice that on the south side of the property is I-1 zoned property. As was discussed with the matter before you earlier, under Lincoln's Comprehensive 2050.
Move it down a little.
Oh, thank you. So here's the area of the change of zone. This is the I-1 zoned property just south of it. Under Lincoln's comprehensive plan, it's recommended against zoning for residential within 300 feet of industrial zone property. All of that together means that this property is not useful for due to its small size, is not useful for agricultural purposes. It also can't be used for residential purposes, which is why we're before you asking for a change of zone to commercial. I will say that there is a house located on the north side of the property. That house has not been occupied for years. It is not in habitable condition, and no matter what happens with the property, the intent is to tear that house down. So that is a little bit of an overview of the unique location of the property and why commercial is the best and really the only reasonable use for this property. The intent for this applicant is to rezone this H3 commercial to allow for contractor services. The intent is to build one building that allows 5 to 8 contractor bays on the site. It is, again, if I pull up kind of this large, well, let's go with this map again, a little bit of more zoomed in view. This location is ideal for this because it's right next to Highway 2 to give it easy access. There is the paved access on 91st Street. And also you'll notice that for this property, access can come in right here, and it doesn't have to go through the rest of the development, both development down here or on the south side of First Street here. They can have access right off Highway 2, off of that arterial street into this property. So that's why this property is ideal for even the contractor services. So why it's ideal, what we intend to do there. And then let's go proceed to some of the difficulties of this. Why is this before you? Why is this before you today? Why I'm here today? First, property is a really unique situation because it's outside city limits and it's within the Cheney SID. All of which are very interesting issues I'd be happy to discuss, but those are actually not the reasons that the planning department has recommended against zoning this property. So I'll skip over those, but if you'd like me to expand on those more, I'd be happy to. So the reason that the planning department has recommended against rezoning for this property is because, I just need to leave this map up here so we help tech people. I apologize for that. When you look at this map, what the planning department has requested is that this property owner build a street through the north end of this property for the use of the properties over here. Now, the reasoning behind that is because they feel that it is more likely that those adjacent properties will develop commercial, and when they develop commercial, they will want an access point, as another access point on the north side of the property, because First Street here is a rock road. Not suitable, they feel it isn't suitable for commercial traffic. Now this is where I wanted to reorient you to the idea that this is an individual. This isn't a commercial development, this isn't an office park. The problem with installing a road is that even if we install it to Lancaster County standards, so at a rock road, that would cost at a minimum, the last estimate we got was $40,000. This property itself is only worth $80,000. This is not your commercial development with several buildings, several bays. This is 3 acres. And so more than that, the need for this road isn't caused by this property rezoning. It's caused by the future potential for the properties next to it to rezone. So you'd be asking for an individual lot owner to build a road for the use of the adjacent lot owners on the potential that they may rezone in the future. And finally, this area is already developing commercial. If you look at it, if we look at the larger zoning map again, if I pull this down enough, all right, you'll see that we're looking to zone this property. It's already I-1 to the south. If you go down the street, this property, just with one property in between, is already H3. You see if you continue down this street, you've got I-1, and then even down First Street, we've got more H3, and this property is actually zoned, it's a mix of AG, ag, and residential, but it's actually a painting business that was grandfathered in. So the point is that H3 is not, it is not out of character for the area, for what we're asking. So then to bring back to why is 5B on your agenda as well. So 5B is a conditional, approving a conditional annexation and zoning agreement. And so the city, at Planning Commission, the city recommended that first denial, but that if the Planning Commission recommended approval, they would do so on the condition that the applicant build that road through their property. And so where we came to try and find a middle ground with the planning department, and that was that this project does not support building a road. We can't pay to build a road for the neighbor's use, a road that doesn't benefit this property or this project, but the applicant is interested in the development of the area. So what he is willing to do would be to agree not to build on that north portion of the property, so that at the time, that if and when that property, adjacent properties do develop commercial, there's not a building in the way, that it is possible to get a street through that area. And so that was intended as a middle ground to try and meet some of the needs of planning to accommodate that future growth, but also not to overburden this project. And so that is not the zoning agreement that was in front of the commission. So if you're looking in your packet and there's my letter to the commission, that's where some of the discrepancy is. That the agreement that was in front of the commission is different than the one that was attached here as 5B. The 5B is the one that we proposed, that is that upon rezone, the applicant will leave that north portion of the property unbuilt, that he can use it for a driveway, he could use it for open storage, but he won't build a building there for at least 10 years, so that if the property develops out, there is the potential for a road to go through there. So with that, I would be happy to answer it. So first, to summarize, what we're asking for you today is first to approve the change of zone from AG to H3 commercial. Why? The reason being is that commercial is really the only use you can put this property to. Practically, it can't be used for agricultural uses. Under the city's policies, it can't be used for industrial purposes. Commercial is really the only practical use. So we're asking you to rezone it from AG from AG agricultural to H3 commercial. And that also, if you are willing to do that only upon some measure of guarantee that there may be a street that goes through to allow access to those adjacent properties if they develop out, that then you would approve the change of zone with approval of the conditional annexation agreement. All right. So with that, I will ask if there's any questions. I'm happy to clarify anything else or to answer any of the questions about the location of the property, and otherwise Mr. Hanshaw is with me too to just introduce himself and the project he'd like to build.
Councilman Beckius?
Yes, thank you, Chair Bowers. Ms. Post, just so I am clear, your client is still offering the reservation, if you will, of the north side of the parcel for future use should neighboring adjacent landowners choose to develop within 10 years. Is that correct?
Yes, so under the agreement, it would be that he would not build a structure in that area. So that means that if
a neighboring landowner wanted to come along and purchase or work out some other agreement to use that land to access their piece, that's on the table. Okay.
Yes.
Okay. Thank you.
Councilwoman Raybold?
You know, Ms. Post, in some of the other conditions that were laid out, they talk about gain of release from Rural Water District Number 1. What is that reference?
Yes. So this property is actually within Rural Water District Number 1. When you are a user of rural water, if you're on their system at the time you're annexed, there's actually a fee that the property owner or the city would have to pay to rural water in order to release you from the rural water system. And so that is, I believe the logic behind that is that they need users to support their system, and when you take a user off, there's a cost to their system. This case is actually unique, is that rural water is available, but actually when we talk to rural water, this property is served by a well. So they're actually not connected to the rural water system, and there is, in the conditional annexation agreement, is also the condition that the applicant is willing to agree to, that should they become a user of rural water, and should that fee apply, that upon annexation they would pay that fee.
And did your client agree to pay the fee, I thought there was some question about him being released from that agreement, the vote, or I may have misinterpreted that.
I can tell you that we agreed that in the conditional annexation and zoning agreement, there is the agreement that if the property is annexed, the property owner will pay that fee to rural water. So that is, so if they become subject to that, they'll pay that. The issue of if they become is whether they actually connect to rural water or they're able to make use just of their well system. But so that way the city's not liable for that fee if that becomes an issue.
Okay, thank you.
Councilman McGinnis?
Yeah, I got a quick question. Maybe I'm wrong. Is this an annexation? Are you asking to be annexed into the city of Lincoln?
Great question. This is outside the city of Lincoln. So this is adjacent to the city limits, but it's outside the city of Lincoln. So it is within the city of Lincoln's extraterritorial jurisdiction. So that's a 3-mile limit outside the city limits where the city still has zoning jurisdiction. So still subject to city zoning jurisdiction, but we're outside city limits. Typically, the city's annexation policy would require that if you're going to be zoned commercial outside city limits, you must be annexed. This is a unique situation that this property is actually part of the Cheney SID. And so the city has taken the position, and a good policy position, that they cannot annex properties piecemeal, one property at a time out of the Cheney SID. They either have to annex the entire SID or not annex the individual parcels of the SID. The reason being, I understand the logic behind that, but if anyone else wants to comment to that, I'm sure they can give more nuance. But part of that is because Cheney provides the sanitary sewer system for the SID, and if you were to start taking individual users off their sewer system, they may not have the capacity to support that, both user fees and also there just has to be a certain amount of effluent in the system for the system to work. And so if you start taking properties off, their system won't work anymore. So that's why you wouldn't want to take individual properties off. So then the only other way to be released from the Cheney SID is to go ask and have the Cheney SID agree to release you. I can tell you we did ask to be released from the Cheney SID, and Cheney declined to release the property, again, because they're One of the main reasons being that they're very concerned about the use of, about having enough users on their lagoon system to continue to have those systems to be effective. So that is why in this situation, it is the rare situation where we're asking for commercial zoning outside city limits. And actually it is, while that is not in line with the city's traditional annexation policy, that's actually not the reason that the city recommended against this rezoning. The planning's recommendation of denial was not because we're outside city limits, it was because of that road, the street connection to the properties to the east.
I would follow up real quick. As I remember, the Rural Water 1 district annexation, or the agreement with the city and Rural Water 1 was when the city annexes it. When the city annexes it, then that's when the payment trigger is. So if the city's not annexing this, there shouldn't be a fee to Rural Water 1 at this point. Now, it'd be, I say, courageous of your applicant to say they would help pay that, but it will be up to the city to pay that fee to Rural Water 1 as we go forward. Also, too, it looks like that property next to you has access to First Street on a street stub called Smith that is owned by the city of Cheney, so they have access. It's not like they are going to be out of access to a roadway.
Correct.
That's why I don't know why the city wants another access point.
Correct. All of the properties to the east have access to First Street. Mm-hmm. This property developing does not change that they currently have access to First Street. The question is that First Street is, as I understand it, is a rock street. So the question is whether that street could support commercial traffic. So if this property is zoned commercial, and then if the properties next to it are zoned commercial, and then if those commercial uses drive heavy truck traffic, there would be a concern. I think that's 3 levels of ifs there. There would be a concern about the ability of that road to support that traffic. To which point, all of those properties would have to be rezoned, and they would have to go through the process of making sure that those properties could support the proposed uses, and the road should be addressed at that point. So first, the integrity of First Street should be addressed at the time that those properties that take access from it are asking for that commercial rezoning.
Any further questions, Councilman McGinnis?
No, thank you.
Councilman Shob?
Thank you, Mr. Chair. My question is going to use Councilman Guinness's question as a springboard, and you did answer the rural thing. This is outside the city limits. Why are we being asked to rezone? Thank you for answering that. The follow-up is, you said it was also in an SID currently?
Correct.
If we annex it, does that pull it out of that SID? You said you asked to be released. If we annex, does it stay part of that, or does the status change?
The status would change, that it has to be either in the city or the SID.
Okay, thank you very much.
Any further questions? Councilman Washington?
Well, that seems like we're starting in a fight with the SID. I'm a little confused by the, yes, we can zone outside of city limits, but if we zone and we annex, you can't be in 2 places at the same time. If the SID doesn't want to release them, but we say we want, I'm a little confused by what feels like setting us up for an argument.
Yeah, and I would say that the SID doesn't have zoning authority.
Right.
At all. They have no zoning authority. It's only the City of Lincoln zoning authority that applies. The SID provides utilities and provides the infrastructure for the development. If you imagine this development when it was originally built was well outside city limits. Mm-hmm. Not the case today, but when it was built. And so the role of the SID is to provide that infrastructure. And so that is the streets, that is the sewer, and that's the water. And so that's why what we're proposing here would allow that commercial rezoning that is completely within the city's authority for zoning and not an authority that the SID ever had, while still using the utilities of the SID, which in this case, it is actually that the SID needs to keep users on their facilities to keep them working. And so that is where really some of the rub comes with the SID, is when you start asking to take users off, mm-hmm. is that they need those users to support their facilities. And so that's why it's really an all or nothing, either annex the entire SID, but either annex the entire SID or don't, but not one piece of property at a time.
Councilman.
I don't think they're asking to
They're
be
not
annexed.
asking to be annexed.
No.
And
Correct.
our zoning
Correct.
isn't going to be a de facto annexation.
Correct, yeah, so to clarify, under this proposal, this property would not be annexed and it would not come into the city of Lincoln because it can't be, because it's still part of the SID. So the only thing that we would be changing is the zoning. And the impetus of the proposed conditional annexation and zoning agreement is to address some of those issues that would arise upon annexation, such as the rural water fee that says, we're not being annexed now, but if and when this property is annexed, who pays that water connection fee? If and when this property is annexed, how some of those services are provided. And so that's where that annexation agreement, even though this property is not currently being annexed, and the zoning, annexation and zoning agreement would come in.
Any other questions? Okay, seeing none, we'll call you back up for rebuttal in a little bit.
Thank you.
Director Carey?
David Carey, Director of the Planning Department, 555 South 10th Street.
Are there any questions for Director Carey? Councilman McGinnis?
Yes, Director Carey, has the city annexed any Cheney property before?
There have been a couple of different instances where this topic has come up. There a property on the north side of Highway 2 that was in the Cheney SID was released by the Cheney SID in the past, not distant past, but in the past. And so we have a bit of a proxy situation that we could discuss, and that was a project that was south of the residential on the north side of Highway 2 there, west of 98, South 98th Street. That we like to point to that because we did have an annexation and zoning agreement with that, which required improvements similar to this suggested property, which was to have right and left turn lanes be built along with the approval of the change of zone, which also would allow for some contracting services on that piece of property. The difference there is that they were released by the SID. In this situation, both the applicant and the city did ask the Cheney SID to release this property, and they said no, and therefore we are unable to annex. And so where we are on this topic is that we want to get the typical improvements for commercial change of zone and commercial activity that would be the case if we were annexing a property anywhere. And then also pointing out that we'd want to limit the amount of new commercial activity within our zoning jurisdiction that remains outside of the city limits, and therefore it is not a benefit to the city at that point.
Councilman Beckius?
Director Carey, could you give me an overview of the development of the mini storage units on the east side of First Street that looks to have occurred around 2016 or so?
Yes, and that is an area, we also did have a zoning agreement with that one. We did limit the use to mini storage. That was one part of that. And the crux of that conversation was that there was an existing house on there with a bathroom. There's a requirement with this size of mini storage to have a bathroom. And so it was looked upon as being kind of a one-for-one swap for as far as an impact is concerned on the property. And so that was the crux of that consideration at that time.
And it looks like Yankee Hill Road or First Street, depending on where I don't know where that line delineates, Director Carey, but it looks like that remains gravel today.
Yes.
Okay. Was there a reason that, I'm assuming because of the lighter use of mini storage, right, is the reasoning that planning did not require any pavement or improvement upon First or Yankee Hill?
Well, as far as also not annexing the property. So we were not that gets into that, if we annex it, we would want to have those improvements. Obviously, that's not possible in this situation as well as what we're talking about today. So we had a similar conversation, but it gets to what you just said, which is limited activity that has less of impact on those local roads. And that was the point being made by the SID in their letter to us in opposition to this change of zone, is that they do have a concern with the increased traffic from commercial activity. So that is also part of the consideration here.
Sure. And I do, and then could you walk me through the ideology of the planning department as to some of the items mentioned previously in terms of parcels that have access to First Street, when and if they should decide to develop out at some later date, why you would not simply require them to make improvements to First Street at that point in time and take access that way, as opposed to the ideology of putting a road through the parcel that we're discussing today to access those points.
So the main reason for that is that in a typical conversation about approving a new piece of property for commercial activity that has proximity to residential areas, is that we like to limit the interaction of those two different types of traffic. And so what we typically do is we have those site improvements happen with a road, in this case a potential road that's going to connect to other new commercial properties, and keep that commercial activity and that traffic separate from what could also be down on First Street, which would put it right next to existing residential. So it's just the idea of keeping that traffic separate and trying to do good planning and then therefore also allowing for more property to be developed with that type of access and improvement on the north side instead of on First Street. So we believe it would be also a benefit to those properties if they wanted to change zone in the future to have that infrastructure there and better access.
Thank you, Director Carey.
Thank you, Mr. Chair. Mr. Carey, thank you for coming forward. I had a question ahead, but you said something in your initial testimony about, and I'm not sure how it came out, of controlling industrial growth in our community. And I can't remember exactly what it was, but this area has some industrial development already, and it's not inside the city limits.
Mm-hmm.
And your statement led me to believe that you say we shouldn't encourage any industrial growth outside of the city limits. I misunderstood you. Please help me understand what you were saying.
So all the different uses that are in this Cheney SID are kind of
it's kind of hodgepodge.
Predating the city being that close to them and growing out to them. So yes, there's a lot of different uses that are out there. Generally speaking, our policy is not to approve commercial and industrial zoning and activity and uses outside of the city limits of Lincoln, and also not inside other local jurisdictions, such as the smaller towns and villages and cities that we have in our county. We believe that those cities and towns, as well as the city of Lincoln, can better serve that higher intensity level of use, commercial and industrial, inside the jurisdictions of the municipalities, because we do have the urban services, the water and the sewer and streets. So that is the basic reason for that. I would like to clarify that, so I thank you for asking that question. I think going back to the applicant's testimony, there was a comment about that there is no use for this property, and I would say that that's not correct. The use that's there and available to it is the existing use, which is a residential house. And because that property predates the 1979 zoning ordinance, it still retains that right, even though they might need to rebuild. So just because it's proximate to industrial zoning, it's not going to be prohibited from having that current use continue. So there is a use that could happen there.
Okay, and if I may, Mr. Chair, Lincoln's growing. We're being challenged every week to address issues like this. I've seen in the past where the planning department and the planning commission have worked toward getting toward yes. And tell me about, have we really tried hard to get to yes and help this developer? How do we make this happen?
Yeah, so we are very typically in the position of trying to get to yes, and we almost always do in some form or fashion. And we don't like to recommend denial and In this case, we felt like it was a necessary recommendation, and our planning commissioners agreed with that 9-0 to deny. In this case, the yes path is to approve this change of zone with a zoning agreement that does require the typical public infrastructure that we would get with other properties that we would otherwise be annexing into the city, which is the beginnings of that street and getting that paved and setting that up for future extensions of that piece of property, the other changes of zone potentially in the future, as well as just in all of our developments, we have the agreement that the extension of urban city water and sewer to serve the property would be paid for by the developer. Those are the two main differences in what you have before you for the annexation agreement from the applicant and what we were proposing to do. If those typical improvements and requirements for new commercial zoning were agreed to by the applicant, we would be proposing approval.
Thank you.
Any further questions for Director Curry? Okay, seeing none, thank you so much.
Thank you.
Is there anyone else here that would like to speak on this item? Okay, seeing none, Ms. Post, would you like to provide a rebuttal?
Thank you. Just one or two points to clarify. And that is that yes, we understand that it's typical that the city does not recommend additional commercial activity outside of city limits. Understand that, but this is a very unique situation. The city has grown up almost around Cheney, and it's at a point where the best use for this property is a commercial use. Even though it's outside city limits, and where we would, if it was possible to proceed with the annexation, we would have gone that route. I will say that we did work with the city and try to find ways to accommodate these needs. We actually submitted the application almost a year ago and have been working with city departments to try and find a way to address needs since then until we got to this point. We looked at some very creative ways to do that, and I appreciate that at certain points I think we had 3 or 4 different jurisdictions on a call to try and figure out a creative way. NDOT, the county, the city, and the Cheney SID. The problem is that the issue that we're looking to solve here with this road is not an issue that's caused by this rezoning. It would be caused if the property is next to this property rezone, if there is a larger commercial rezoning in the area. And so that's why without the cooperation of the adjacent property owners, that this property owner and this project really can't solve those problems. They're not created by this property. They really can't be solved by this property with this small of a project. And then also to touch on Director Carey's last point, the issue of extension of utilities to this property. So first, on the typical annexation agreement, it's very typical that to be annexed, the city would require that the developer extend utilities to their property. In this situation, first, like we've discussed, it can't be annexed. So it has to be served by the rural water, by the SID utilities until such a time as it is annexed. It's also the unique situation that this will be an all or nothing annexation whenever it is annexed. It will be a complete annexation of the Cheney SID. And so in that case, there's going to be a larger plan for providing utilities to the entire SID at this time. And so that's why we didn't see it as equitable or really making a lot of sense to require this developer to pay solely to extend utilities from where they are in the city to this property, to then have the larger agreement for Cheney SID to extend it throughout the SID. Basically, have this property paid disproportionate share of the costs that will then be shared by the entire SID when the entire SID is annexed and utilities provided. And so that's where, if you look at the conditional annexation zoning agreement, this builder, I'm used to saying developer. As I emphasize, this is not a developer. This is a 3-acre, 1-building project. So in this case, this builder has agreed that what they will do is to connect. They've agreed they will pay all the costs of connecting to the system when it comes in. And also, as a reminder, likely when Cheney is annexed and utilities are brought to to the whole of Cheney SID, it's likely that that would be done through a sewer district or a street paving district that would require this property owner to still pay a portion of the cost as a property owner within the Cheney SID. And so that's where they're not escaping the cost to bring utilities into the Cheney SID at such a time as that would occur. So with that, I will ask if there are any other questions. Otherwise, well, first I'll ask if there's any other questions and then ask Mr. Hanshaw to come up and introduce himself.
Are there any questions from Ms. Post? Okay, seeing Councilman Vecchius, you got a twinkle in your eye.
Ms. Post, you and your client have provided a framework to the city under which you would potentially agree to provide access via the potential road that we talked about, but it's just a framework at this point in time, correct? There's been no reason to go down the road of actually drafting any sort of agreement or anything.
Well, there was the conditional, so let me give some facts and we'll see if we're talking about the same question.
Mm-hmm.
There was a conditional annexation and zoning agreement proposed at Planning Commission. That was an agreement that stated it would require in that case, the city recommended denial, but in the case the Planning Commission did approve, it was a different conditional annexation and zoning agreement that would require the applicant to build a road to county road standards. The applicant, we discussed it and were not able to agree to that because of the costs involved, because as Director Carey said, it would greatly benefit the properties, adjacent properties, but it doesn't benefit this property owner's project at all. And so that's where the agreement that is on the agenda today is what we proposed back to Planning Commission. And so it is an agreement. If it is something where I think it could still be amended before a final vote if that's something that this council would need to see to approve the zoning, but there is the agreement in place where it could be passed with that.
That's what I needed to know. Thank you.
Any further questions from Ms. Post? Councilwoman Raybold?
Sure, this is for Ms. Post, but typically an agreement that you have tried to work out here where the developer or the builder, it says developer here too, agrees to reserve a 60-foot wide area in the northern half, but it doesn't discuss any future financial responsibility for that road at the time of annexation. So I see that element was not addressed. And I'm sure you're thinking that the additional property owners, if they do a development, then they perhaps would be responsible for that. But it seems like in our past experiences, we've never seen it work out that way. So could you tell me a little bit more? You just want to reserve or provide an easement, or I'm not clear what this tells.
To address that, what we're asking there would be that the builder would agree to reserve an area that's of 60 foot, potentially for future right-of-way, that they wouldn't build a structure. So that is not an easement, that is not an agreement to build a road. What that does is make sure that there's not a structure in the way, so that if someone does want to come and develop the adjacent properties and wants to come purchase the property for a road, there's not a building in the way, that it is open so that can be done. Now, if the city would want to see some sort of option agreement, so that would be a requirement that if someone wants to come develop, the applicant would be paid fair market value, but would be required to sell that. That's definitely something I think we could consider as a change to the agreement between now and a vote on council, so that there is that obligation to sell the property if another developer comes through. And so that's where now, who's responsible for it? I think that would depend on that subsequent developer, whether they build it a city street to city standards, whether they build a county road to county standards, whether it is built as an easement. It depends on what's actually built there, and that would be only built at the time that a subsequent developer would get, a subsequent builder, developer, whatever that person is, would come and get zoning approvals.
And so you're saying that this agreement was not put before the planning commissioners?
It was provided to the planning commissioners. It was provided to them to review, and they recommended, it was a recommendation to deny the rezone.
Any further questions from Ms. Post? Okay, seeing none. You said you wanted to bring up your
Yes.
applicant? Okay.
Mr. Hanshaw's here. I just wanted to introduce him and have him tell you a little bit about what he hopes to do with the property.
Hello.
Hello.
Howdy. Chance Hanshaw. Not sure which address you'd like. This 8230 South 91st Street. I guess a little bit about myself. I have my wife here, Marcy. She's owns Carmela's Bistro and Wine Bar. We're both, like I said, self-employed. My background with Cheney is I was born when we lived in Cheney in 76. So I know the area very, very well. I've seen it develop. And since then, my dad has been on the SID board. So, I mean, I know the SID very well. I mean, like the problem they had with the mini storages was at that time they thought that they didn't need any more hookups, or that the SID couldn't handle any more hookups, and it was actually the opposite, that the SID needs hookups, and I'm not actually on the SID. The previous owner I bought the land from never did hook up the SID, so actually if I go in and I hook up the SID now, because we have just a septic system on the property now, I will actually be helping the SID out by producing more stuff going to the lagoons.
Revenue payers. Yeah.
And then I'm not hooked up to the rural water, but I did talk to rural water. They said I could hook up, and yes, of course. I mean, I know it would be my responsibility to pay to unhook. Then that's part of doing business, I guess. Cost of doing business. I appreciate planning's willingness to work with me with that street and some other stuff that we had talked about before. Ann Post has explained where I stand on not being able to afford to put that street in. I want to help the city out, and I appreciate them helping me out by talking to me here. So, like she said, I'd like to offer setting aside that piece of property in case, who knows, maybe I'll own the property behind there. Maybe I'll be the one putting the street in. I mean, I know the guy that owns it. He's not interested in selling right now. Maybe he will someday. So we'll be back here again, and I'll be the one paying for the street. But anyway, I don't know if anybody has any questions for me.
Are there any questions for Mr. Hanshaw? Okay, seeing none, thank you so much for coming down and introducing yourself.
Thanks so much.
Okay, we had opening, public hearing, rebuttal. Let's go ahead and move on.
I'll be calling item 5C, amending the pay schedules for the employee group whose classifications are assigned to the pay range prefix by the letter A by creating the classification of epidemiologist 3.
Good evening.
Oh, not yet.
It's kind of evening. Nicole Gross, Human Resources, 555 South 10th Street. The Public Health Epidemiologist 3 is being created at the request of the Health Department. This creation will add another level in the epidemiologist classes, and it will fall between the epidemiologist 2 and the supervisor class. We do have representatives from health here if you have any specific questions about this classification.
Are there any questions? Okay, seeing none, is there anyone here that would like to provide comment on this? Okay, seeing none, we'll move on to the next one.
I'll be calling item 5D, amending the pay schedule for the employee group whose classifications are assigned to the pay range prefix by the letter N by creating the classification of utility equipment operator 3.
The utility equipment operator 3 is being created at the request of Lincoln Transportation and Utilities Department. This creation will add another level to the utility equipment operator classes.
Is any questions from the council? Seeing none, is there anyone that would like to speak on this item? Seeing none, we'll go to move on.
I'll be calling item 5E, amending pay schedule for employee group whose classifications are assigned to pay range which is prefixed by A by changing the pay range class 5022 solid waste operations supervisor from A09 to A14.
The pay range change for the solid waste operations supervisor is being changed because we have a high turnover in this position. We hope this change will help LTU with recruiting and retaining employees. This pay range is equal to other supervisors in LTU.
Any questions from the council? Seeing none, is there anyone that would like to provide comment on this? Seeing none, we'll go to move on.
Item 5F is amending the employee group whose classifications are assigned to pay range, which is prefixed by the letter A, to change the title of district supervisor to street maintenance superintendent.
The title change is at the request of Lincoln Transportation and Utilities. This also includes a pay range change. Again, this pay range is being set to be equal with other supervisory classes in LTU.
Any questions from council? Seeing none, is there anyone here that would like to provide comment? Seeing none, we'll go ahead and move on.
Item 5G is amending the employee group whose classifications are assigned to pay range, which is prefixed by the letter W, to change the title of Information Services Manager to Chief Information Officer.
This is a title change request to use Chief Information Officer. We're trying to modernize our titling of this. This has been a working title for quite a while, so we're trying to make this official.
Okay, any questions from council? Seeing none, is there anyone that would like to provide public comment? Seeing none, we'll go ahead and move on.
Item 5H is amending the employee group whose classifications are assigned to pay range, which is prefixed by the letter A, to change the title of Public Health Epidemiologist to Public Health Epidemiologist and Assistant Public Health Epidemiologist to Public Health Epidemiologist 1.
The title change to Public Health Epidemiologist 1 and 2 is being done to match the classification of family titles. So now we will have a 1, 2, 3, and a supervisor.
Okay. Are there any questions from council? Seeing none, is there anyone that would like to provide public comment at this time? Seeing none, we'll go ahead and move on. Thank you.
Thank you.
I'll be calling item 5I, amending section 10.46.110 of the Lincoln Municipal Code relating to vending from trucks on city residential streets, providing that the trucks are not hindering or obstructing traffic, and repealing sections 10.46.110 of the Lincoln Municipal Code as hereto existing.
Councilman Ward, would you like to open on your ordinance that you are introducing?
Sure. Thank you, Mr. Chair. So I'm excited to see this change as an update, actually, to the municipal code. And I see that Ms. Salem is here from Urban Development, and I know that our city attorney will speak to this as well. But I first learned about the need to update the existing code 2 years ago in 2019. In the fall of 2019, we sat in a meeting in Urban Development's department, and Director Marvin was there, and our former city attorney, and also there were several food vendors, and Hallie taught us how to say that day instead of food trucks, taught several of us. At any rate, what we really were talking about that day was how to conduct a food truck pilot program, vendor program. This was obviously before COVID. Anyway, what I learned that day also was that in our neighborhoods as it existed then, and still exists till we update this code, is except for ice cream trucks, or was it just ice cream trucks that could stay longer? We'll hear from staff, she'll correct this. But for food vendors to park in neighborhoods, there was a 10-minute time limit. And so as we proceeded with our discussions, it became clear that to the vendors there that was way too short of time, unless you were parked as a vendor in a customer's driveway. And so what was happening, sometimes our vendors would go ahead and park on the street and take their chances with a ticket. And we didn't want that to be happening. Right, Investigator Parker? And so, right? And so at that time, we decided we would just introduce this today, along with the any other changes we needed. But then came COVID. But here we are today. And so I'm really grateful for all the work that Urban Development and the Law Department has done on this. I did talk to Nick Meistis this morning. He's out of town, but he sent me just a two-sentence email that he asked me to read, if you can endure. It's just very short, but Nick owns Muchachos, and he has been very instrumental in the food vendor, truck vendor business, and been in front of council many times during the pandemic as well. And this is from Nick, the owner of Muchachos. He said, expanding the ability for food trucks to serve in Lincoln's neighborhoods is important to ensuring the ability to serve the public now more than ever. Some people are still not comfortable going out. Graduation parties and wedding rehearsal dinners in backyards allow food trucks to make it easy and fun for people to serve their guests. This would not require plugging meters, sorry about that, urban development, or working with private companies. Public safety measures such as having the window face the curb and not blocking driveways or walkways would be necessary to make this successful. Expanding food truck vendor parking into neighborhoods is a great next step into making Lincoln a leader in mobile food. So that's on behalf of Nick at Muchachos. So with that, Mr. Chair, I would be anxious to hear from staff and our legal counsel as appropriate. Thank you all very much. So this just updates from 10 minutes to 3 hours. So thank you all very much.
No questions.
Yes, if you have any questions, I'm sure staff will be glad to answer them as well.
Johansi Christie, City Attorney. I know that we have Ms. Salem here to help answer any
Urban
particulars.
Development Department.
Yes. I would just add, and I think maybe touch on this, but again, the idea is for neighborhoods, we still have a requirement that trucks cannot be in the congested area of town. Oftentimes what will happen if someone has a driveway that a vendor truck might not be able to get into or something like that, then they could be outside on the in the right of way, but right outside of the owner's property. So,
Right, and I think in just looking at the congested district, at one point we had talked about expanding the congested district to include West Haymarket, and it does not yet fall into the congested district. So I just want you to be aware that we did not amend, I thought we had, but we did not amend the congested district to include West Haymarket. And so it could be something that comes up. And it also defines the food trucks as operating in the roadway, which generally does not include the parking tray. So something I think also we want to keep in mind there. But this would be an excellent step forward in expanding outdoor dining options, helping activate neighborhoods, and something we look forward to continue working on.
Any questions? Councilman Chobe?
Thank you, Mr. Chair. Salem, thanks for coming forward. Mr. City Attorney, thank you for your help. I'm a little fixated on the words food trucks on city residential streets. Most of the time when I hear conversations about food trucks, there are people who work in the downtown area and they want to walk out of their office building and go there. Is that a residential? Why is the word residential streets in there? Is that really important? Does it distinguish between other streets in other parts of the city?
I believe it's the existing ordinance is just being amended to say that it will stand in the roadway longer than 3 hours. So it removes arterial streets, state highways. Those are already in as not allowable areas, congested streets. So I think we generally assume that to be largely residential areas, but it could include other areas that aren't congested districts. Congested districts include, for example, Havelock Avenue, North 48th Street, some of those other areas, and also includes downtown.
I thank you. I appreciate that. I know that someone's going to ask me why we can't see one at some place, and I want to be able to understand why. Yeah. Thank you.
Councilman McGinnis?
Real quick, congested district. Do we have a map of that? You can get me a copy of that.
No, but I can put the language up.
Okay, well, you can get that to me later. I mean,
could probably create a map.
Yeah, the congested district is just generally limited to.
Yep.
There's a description.
Yeah.
Okay.
Zoom out a little bit.
That's fine. Thank you.
Mm-hmm.
Any other questions for staff? Okay, seeing none, thank you so much. We'll see if there is anyone who wants to provide public comment at this time. Okay, seeing no one want to provide public comment, Councilwoman Ward, would you like to close on your ordinance?
I would. Thank you, Mr. Chair. I would just, again, thank Urban Development, Ms. Salem, and Mr. Christie and his staff for getting us to this point and to address, I think, Councilman Shob, your question, because you will get asked that. I think that part of the answer is we do intend, we meaning Urban Development and the law department and our food vendors who are interested, to pick up that pilot program that we had almost rolled out like right when COVID hit. And so to your question, we had, as you may recall, those maps even hit the newspaper. So there will be eventually some, if I'm getting ahead of you, Director Marvin and Ms. Salem, come on back. Or, whoops, maybe not. But, so the answer could be.
Working on it.
Yeah, I think when our numbers are down and staying down, by the time the university is back in session this fall, will put us in a better place, perhaps, to roll out the pilot program. And so there will be other locations for state office workers, for university students, for downtown workers. Does that help?
That helps a lot. I can say working on it. That's what
we are working on it. Keep your fingers crossed. So
thank you.
Thank you very much. Thank you, Mr. Chair.
This is a good ordinance that you're introducing, Councilwoman Ward. Thank you for introducing it.
Thank you very much.
Okay, we'll go ahead and move on.
That concludes our public hearing on ordinances, second reading, and related resolutions. We can move on to section 6, which is our ordinances, third reading, and related resolutions. Item 6A is approving the Tabitha Intergen redevelopment project, redevelopment agreement between the city and Tabitha Intergen LLC relating to the redevelopment of the property generally located between 47th and 48th Streets adjacent to L Street, introduced by Raybold.
So moved.
Second.
Moved and seconded by Councilman Beckius. Any discussion? Seeing none, may I please call the roll? Oh, did you have something you want to say?
No, thank you.
Okay.
No.
Seeing none, may I please call the roll?
McGinnis?
Yes.
Ward?
Yes.
Raybold?
Yes.
Washington?
Yes.
Shob?
Yes.
Beckius?
Yes.
Bowers?
Yes.
Motion carried 7-0. Item 6B is amending the fiscal year 21-22 CIP to authorize and appropriate $3,291,750 in tax increment financing for the Tabitha Intergen redevelopment project, introduced by Raybold.
So moved.
Second.
Moved and seconded by Councilman McGinnis. Any discussion? Seeing none, may I please call the roll?
Ward?
Yes.
McGinnis?
Yes.
Beckius?
Yes.
Raybold?
Yes.
Shob?
Yes.
Washington?
Yes.
Bowers?
Yes.
Motion carried 7-0. Item 6C is authorizing the issuance of tax allocation bonds for the Tabitha Intergen redevelopment project in amount not to exceed $3,291,750, introduced by Raybold.
So moved.
Second.
Moved and seconded by Councilman Beckius. Any discussion? Seeing none, may I please call the roll?
Shob?
Yes.
McGinnis?
Yes.
Raybold?
Yes.
Ward?
Yes.
Washington?
Yes.
Beckius?
Yes.
Bowers?
Yes.
Motion carried 7-0. Item 6D is Comprehensive Plan Conformance 22001, declaring approximately 1.65 acres of city-owned property generally located at 2201 South 84th Street as surplus, introduced by Raybold.
So moved.
Second.
Moved and seconded by Councilman McGinnis. Any discussion? Seeing none, may I please call the roll?
Washington?
Yes.
Beckius?
Yes.
McGinnis?
Yes.
Shob?
Yes.
Raybold?
Yes.
Ward?
Yes.
Bowers?
Yes.
Motion carried 7-0. Item 6E, Street and Alley Vacation 21009, application of Dennis Shower to vacate a portion of North 33rd Street at Shower Drive, generally located at North 33rd Street and Shower Drive, introduced by Raybold.
So moved.
Second.
Moved and seconded by Councilman Beckius. Any discussion? Seeing none, may I please call the roll?
Beckius?
Yes.
Raybold?
Yes.
Ward?
Yes.
Shob?
Yes.
Washington?
Yes.
McGinnis?
Yes.
Bowers?
Yes.
Motion carried 7-0. Item 6F is Annexation 21011, application of Sofo Housing LLC and the City of Lincoln to annex approximately 61.28 acres, more or less, on property generally located at the northeast corner and southeast corner of West Pioneers Boulevard and South Folsom Street, introduced by Raybold.
So moved.
Second.
Moved and seconded by Councilman McGinnis. We need an amendment.
Yeah, I'd like to make a motion to amend 2237 by adopting a substitute attachment to correct a typo in the legal description.
Second.
Moved and seconded by Councilwoman Washington. Any discussion on the motion to amend? Seeing none, may we please call the roll on the motion to amend?
Beckius.
Yes.
McGinnis.
Yes.
Raybold.
Yes.
Schob.
Yes.
Ward.
Yes.
Washington.
Yes.
Bowers.
Yes.
Motion carried 7-0.
Okay, now back to the main motion. Any further discussion on the main motion? Councilwoman Raybold?
This is a very exciting new project for more affordable housing in the Southwest District, so of course I'm going to support it.
Sounds good. Any further discussion? Okay, seeing none, may we please call the roll on the main motion?
Beckius.
Yes.
McGinnis.
Yes.
Raybold.
Yes.
Schob.
Yes.
Ward.
Yes.
Washington.
Yes.
Bowers.
Yes.
Motion carried 7-0. Item 6G is approving the annexation agreement between the city and Sofo Housing LLC for the annexation of property generally located in the area between South Folsom Street and West Pioneers Boulevard, introduced by Raybold.
So moved.
Second.
Moved and seconded by Councilman Beckius. Any discussion? Seeing none, may we please call the roll?
Beckius.
Yes.
Ward.
Yes.
Washington.
Yes.
Schob.
Yes.
Raybold.
Yes.
McGinnis.
Yes.
Bowers.
Yes.
Motion carried 7-0. Item 6H is change of zone 21055, application of Sofo Housing LLC for a change from an AG Agriculture District to R4 PUD planned unit development with associated waivers on property generally located at South Folsom and West Pioneers Boulevard, introduced by Raybold.
So moved.
Second.
Moved and seconded by Councilman Beckius. Councilman McGinnis?
Yes. Again, this is a great project. Want to compliment the developers for spending the time and effort to get this done. It shouldn't be this hard to work with a city on a lot of projects and to get to yes. And this one seemed to be pretty hard, but we got there. So this is a good start and we'll move forward.
Councilwoman Washington?
I'd like to put forward a motion to amend on this one to revise the perimeter setbacks following further discussion and negotiation with the developer. And it shows again that a little bit more conversation, a little improvement.
Second.
Moved by Councilwoman Washington, seconded by Councilman Beckius. Any discussion on Councilwoman Washington's motion to amend? Seeing none, can we do a roll call vote on Councilwoman Washington's motion to amend?
Ward.
Yes.
Raybold.
Yes.
Beckius.
Yes.
Washington.
Yes.
Schob.
Yes.
McGinnis.
Yes.
Bowers.
Yes.
Motion carried 7-0.
Okay, any further discussion on the main motion? Seeing none, may we please call the roll?
Ward.
Yes.
Raybold.
Yes.
Beckius.
Yes.
Washington.
Yes.
Schob.
Yes.
McGinnis.
Yes.
Bowers.
Yes.
Motion carried 7-0. Item 6I is annexation 21009, application of the Lincoln Housing Authority to annex approximately 13.59 acres, more or less generally located at South Folsom Street and West Old Cheney Road, introduced by Raybold.
So moved.
Second.
Moved and seconded by Councilman Beckius. Any discussion?
Yay.
Seeing none, may we please call the roll?
McGinnis.
Yes.
Washington.
Yes.
Ward.
Yes.
Schob.
Yes.
Raybold.
Yes.
Beckius.
Yes.
Bowers.
Yes.
Motion carried 7-0. Item 6J is approving the conditional annexation agreement between the City and Housing Authority of the City of Lincoln for annexation of property generally located in the area of South Folsom Street and West Old Cheney Road, introduced by Raybold.
So moved.
Second.
Moved and seconded by Councilman Beckius. Any discussion?
Yeah, quick discussion. Maybe I could have someone from urban development. Is there going to be a redevelopment agreement come forward on this one, or is this it? If at one point I heard there would be TIF agreements being brought forward on the housing authority property?
Dan Marvin, Urban Development, 555 South 10th Street. No, this area was, in a previous blight study, did not include the area of the Lincoln Housing Authority, and that they'd be moving forward without TIF assistance.
Okay. Okay, thanks.
Has been discussed, but no.
Okay.
Any further discussion? Seeing none, may we please call the roll on the motion?
Schob.
Yes.
Washington.
Yes.
Ward.
Yes.
Beckius.
Yes.
McGinnis.
Yes.
Raybold.
Yes.
Bowers.
Yes.
Motion carried 7-0. Item 6K is change of zone 21051, application of the Lincoln Housing Authority for a change from AG Agriculture District to R4 Residential District on property generally located at South Folsom Street and West Old Cheney Road, introduced by Raybold.
So moved.
Second.
Moved and seconded by Councilman Beckius. Any further discussion? Seeing none, may I please call the roll?
Raybold?
Yes.
Washington?
Yes.
Schob?
Yes.
McGinnis?
Yes.
Beckius?
Yes.
Ward?
Yes.
Bowers?
Yes.
Motion carried 7-0. Okay, that concludes our ordinances third reading and related resolutions. Section 7 is our resolutions first reading, items 7A through 7G. Section 8 is ordinances first reading and related resolutions, items 8A through 8C. Section 9, pending list date certain, items 9A and 9B. And Section 10, our pending list is items 10A.
I'd like to move we adjourn.
Second.
Moved by Councilwoman Raybold, seconded by Councilman Beckius. Any discussion? Seeing none, may I please call the roll?
Raybold?
Yes.
Washington?
Yes for her.
Yes.
She said yes, I heard her.
Ward?
Yes.
Schob?
Yes.
Beckius?
Yes.
McGinnis?
Yes.
Bowers?
Yes.
Motion carried 7-0.
All right, we stand adjourned.
Let's go do that before you go. You got his attention, he's all right.